We first saw Mr. Ross what feels like forever ago. We haven't seen him much since. That's because his camera's turned off in all of the pre-trials. That's because they've been working on setting up a new live lineup. Why? You'll have to watch if you don't remember. If you do remember and don't feel like watching, skip ahead to 39 and a half minutes. Here we go. The story of Mr. Ross, the bank robber, allegedly. This is Mr. Ross. We previously saw him in Judge Simpson's courtroom when he infuriated the judge over his attempt to lawyer his own hearing and label his lawyer, Mr. Lauren Brown, as ineffective counsel.
Ready in that matter.
Well, hold on a moment. Go ahead.
Alex Jablowski on behalf of the people.
Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Virgil Ross. Mr. Ross, please state your name for the record.
Virgil James Ross.
Hold on one more. Yes, this is the one.
He had 2 cases.
Oh, he's got 2.
I didn't realize that. So this is not.
What she's trying to tell Judge Simpson is that Mr. Ross has 2 cases, and it's kind of confusing. You see, he's in court today on a home invasion case. That home invasion occurred on March 7th, and he was arraigned on March 17th and given a $50,000 cash or surety bond. The problem is that before he was arraigned on that case, he was arraigned on a bank robbery case that actually occurred after the home invasion case. When he was arraigned on that case, he was given no bond. He's pretty confused about this as well.
Not the one that he adjourned. That one did get adjourned.
Oh, that other one got adjourned. This is okay. I was not aware of that. Okay. All right. What are we doing in this case of his?
Your Honor, before we get started, I believe Mr. Ross would like to address the court.
Mr. Ross.
Yes, Your Honor, there's a breakdown in communication between me and my current counsel, as well as the public defender office. At my arraignment, I was denied bond. The arraignment was for an alleged bank robbery charge, and the public defender used MCR 6-106B to deny me bond. Based on his rules stating that I've been convicted of.
Oh, the public defender did that?
Yes, and not Mr. Lauren Brown, but the public defender's office, that the public defender that was assigned to me did that. And based on that,
denied you bond?
the magistrate denied bond after they used the Michigan court rules, sir. Okay, so after that happened, stating that I've been convicted of 2 or more violent felonies in 15 years, and this was not true.
This is incorrect. At the time of his charges, Mr. Ross was already on parole for 2 violent offenses, carjacking and a felony weapons violation from 2010. Although he was probably counting those as one offense since they occurred at the same time. It's a pretty common mistake. And also, he possibly assumed that the prosecutor was including his manslaughter conviction from 1995, which was 18 years ago, putting it past the 15-year cutoff date.
The public defender failed to just simply look on MDOC Otis and seeing that I only had 1 violent crime. Also, with my current and present counsel, I haven't been able to put any input or insist in my own defense. I requested motions for discovery and full disclosure, and as well as the custody order, and neither one of these motions are frivolous. Also, I've asked for any type of paperwork concerning my case, and just until 36 hours ago, I was just notified that the 3rd-degree home invasion charge was changed to B&E. That's part of the breakdown in the communication.
I don't know that, sir. Go ahead. I'll let you finish.
Yes, and I understand and comprehend that I'm not entitled to have the attorney of my choice, but also I'm unfortunately indigent and I can't afford to retain counsel. But the Michigan Constitution, United States Constitution said I have a due process right to have assistance of counsel. So I believe that there's good cause that exists where there's clearly a difference of opinion between me and my current attorney. I believe that I should have.
And so your current attorney, the
Yeah.
one with the law degree, you have a difference of opinion. I just want to get this right. Oh,
Yes,
okay.
sir.
Go ahead.
Yes.
Go ahead
Yeah.
then.
I mean, the difference of opinion is I believe that I should be able to assist my counsel in my own defense. And even though it's early, I believe that this agreement has caused a fundamental trial tactic as well as a meaningful defense that in the near future. And I'm just respectfully asking that my current counsel be replaced immediately.
Did your current counsel be what?
Replaced immediately.
Yeah, okay. What date did we set that one?
Your Honor,
I sent you a letter requesting this.
22nd? Okay. Yeah, Mr. Brown, go ahead if you want to respond before I do. I just want to, I don't know if
well, I'll go
Mr.
ahead.
Ross even knows this. He's got another case before me that your counsel's filed a motion to protect your interest in the case. And the court has already gotten a prosecutor's response and we've set it for hearing. So that's interesting, these people not working for you, but go ahead, Mr. Brown,
What
go.
if they're not work? I didn't say they wasn't working.
You know what? You know what? I didn't say you. I said Mr. Brown can go ahead. Mr. Brown.
Thank you, Your Honor. Your Honor, the court should be aware that we put several man hours in this. We've had investigators going across downtown Ann Arbor seeking evidence and information on this case. I've spoken with Mr. Ross several times, twice visited him, spoken to him by phone, and spoken to him with a video conference. Mr. Ross believes that he cannot work with our office, and his belief is affecting our ability to be able to work for him in a zealous manner. So we are working for Mr. Ross. He doesn't believe that's the case, but I think that belief is the real thing here. That's going to cause a problem with our continuing to be able to zealously represent him, as he feels that his opinion on how things should be done is, if not superior, at least equal to ours. So that's all I'm going to say on it.
Mr. Ross, anything else you want to say?
Yes, I just believe that there's no transparency between me and my attorney. I believe that I should have my discovery. I believe I should have my police reports. I have none of these things. And I've been in this county jail for 5 months. Also, I should have been notified earlier of the charge being changed from a home invasion to a 3rd degree. So that in itself, that.
Well, I don't know why you're in, why were you in there 5 months?
I
This
said
case,
5 weeks, sir.
You were 5 weeks, okay.
I haven't got not one piece of paper from the public defender's office concerning either charge.
So let's see. I don't have his bond as denied in this case. Is it the other case that it's denied?
In the bank robbery, yes.
Yeah, that's not before me today.
Yes, it is, sir. How is not? I got 2 cases.
Why? What? Hold on a minute. You're going to tell your attorney what to do, and then you're going to tell me what to do.
I'm not telling nobody.
Or what I have.
You should have 2 cases. You have 2
Listen
cases.
to me. That case, your counsel filed a motion to protect your interest. I just said it to you. The problem that you're having is you're not listening. Mr. Brown filed a very detailed motion with this court that this court reviewed, requested a response from the prosecutor. The prosecutor filed their response. This court immediately set that case because of partially the bond and the issue that Mr. Brown brought before the court. I set that case for hearing. What date, Miss?
The 22nd.
The 22nd at 2 p.m. So, sir, no, that case is not before me today.
So, Your Honor, what I'm saying.
Are we
I don't have any of
understood?
this information. I don't know any of this. I haven't seen the motion.
Well, now you do.
It's horrible.
Here's what we'll do. We'll just make this easy for everybody. What time is that other one set?
2 p.m.
2 p.m. All right. Court is going to find good cause to adjourn the probable cause conference in this matter. I will adjourn it 1 week out so that both of his cases can go together and he can still have his complaint, I guess, that he has. And maybe if he'd listened to his attorneys, he won't have the complaint, but I'll let him do what he's going to do. I'll adjourn it to June 22nd, 2023, 9 a.m. Motion. All right. See? Okay, why don't we do this? If he wants to play it that way, we'll just make both those hearings in person.
Before we watch the June 22nd hearing, let me give you a little background on what happened and what this motion's for. As you know, Mr. Ross is on parole for carjacking and weapons violations. We don't have any details on the home invasion at this point, but the bank robbery made the news. It seems Mr. Ross, who thinks himself far more intelligent than he actually is, went into a Chase Bank in Ann Arbor and handed the teller a note demanding money. He didn't imply that he had a weapon, and no weapon was seen, which is actually good for him since he's banned from possessing weapons because of his parole conditions. The teller gave him an undisclosed amount of money, and he fled on foot. Authorities were able to apprehend him within 10 minutes. All of this is alleged, of course. It seems pretty cut and dry. However, Mr. Lorne Brown is a much better attorney than Mr. Ross gives him credit for. Mr. Brown filed a motion to have a live lineup identification with Mr. Ross. The reason for this is because 9 of the witnesses from the bank were unable to identify Mr. Ross from a photo lineup. Their descriptions of him did not match his actual features. So let's hear the two sides' arguments and see what Judge Simpson decides. This is the motion hearing from June 22nd.
Court does, yes, court does call the cases. People of the State of Michigan versus Virgil James Ross.
We're ready on this matter, Your Honor.
Alex Chappell, keep people.
All right.
Right. Public defender opinion Whitman on behalf of Mr. Richard Ross. Mr. Ross, please state your name.
Virgil James Ross. All right. Couple of things. First of all, this is your motion, Mr. Brown, starting the lineup.
Right, okay, thank you. Your Honor, we're here today for a motion for a live lineup in case 23 F55083FY. This motion is based on People versus McAllister and People versus Gwynn. The court has Mr. Ross before today. He's charged with the count of bank robbery in 5083. The allegations are that on May 11, 2023, Ann Arbor police were dispatched to Chase Bank on a reported armed robbery that had just occurred. There was no suspect present in the bank when the police arrived. So approximately 9 persons were present, none of whom could provide the direction in which the suspect was alleged to have fled. There was a bank security guard, Damon Weeks, who stated his view was obstructed, but described the suspect as a black male with a hood on. And that's cited in the brief there, where you can see that on the body cam. There's a bank teller, Lynn Sleva, who says that she had the best view of the suspect. She stated the suspect was wearing white, had on a white hat, and she could see braids in his hair. That's also in the video at between 1:55 and 2 minutes. Now, there's also a Cynthia Chalkley. She's a teller who allegedly, she was a teller who was allegedly robbed, and she described the suspect as a black male with black hair. That's all, that's in the police report. Ms. Sleva stated that she saw the suspect best and was asked to do an in-person identification of the suspect while he was in custody. So Ms. Sleva was accompanied by police, the Ann Arbor police, to a vehicle in which Mr. Virgil Ross was seated. Ms. Sleva told police that the person in the police vehicle was not the suspect. And this is after she had a chance to look right at Mr. Ross sitting in that vehicle. Now, McAllister sets forth that a right to a lineup arises when eyewitness identification has been shown to be a material issue, and when there's a reasonable likelihood of mistaken identification that a lineup would tend to resolve. Let's get a little deeper at it. Clearly. Now, McAllister, as I said, sets forth the right to a lineup when eyewitness identification has been shown to be a material issue. That's the first prong. And the second prong is where a reasonable likelihood of mistaken identification that a lineup would tend to resolve. In this particular case, the eyewitness identification is a material issue because statements made by purported eyewitnesses do not describe Mr. Ross. where witnesses stated the suspect had braids. Mr. Ross has a shaven head and a large beard. No eyewitness described a man with a beard. Ms. Lever told police that the suspect did not have a beard when she saw Mr. Ross. And Mr. Ross, at the time he was sitting in the police vehicle, did in fact have a beard. There's a reasonable likelihood of mistaken identification because Ms. Lever told police that Mr. Ross was not the suspect. Ms. Lever stated she saw the suspect best. She was the only person to do an in-person identification on the day of the alleged incident. Still, Ms. Lever told police that Mr. Ross was not the suspect. We believe a lineup would tend to resolve these issues because Ms. Lever, again, was the only witness asked to make an in-person identification on the day of the alleged incident. Mr. Weeks and Ms. Shockley were both present in the lobby at the time of the alleged incident and gave descriptions consistent with Ms. Lever's description. However, Ms. Lever told police that Mr. Ross was not the suspect, and Mr. Weeks and Ms. Shockley were not asked to make an in-person identification. Court has the discretion to determine whether an in-person lineup is necessary. An in-person lineup is necessary in this case because neither Damon Weeks or Cynthia Shockley nor Cynthia Sylvia have identified Virgil Ross as the suspect they described.
Thank you. Response.
Thank you, Your Honor.
In this case, well, first of all, Judge, I don't know if there's an objection, but I'd like to supplement Mr. Danner's response with 2 photographs that were taken from the video. Can I approach? Yeah. Thank you. McAllister requires, or McAllister suggests that a lineup may be appropriate in a situation where it could resolve any, quote, mistaken identification. In this case, as Mr. Danner pointed out, there really isn't any. And that's due to the good old-fashioned police work of the Ann Arbor Police Department when they investigated this case. Mr. Ross was found a few minutes after the robbery took place at one of the businesses nearby. He was found inside that business wearing a t-shirt, a white tracksuit, orange shoes. The t-shirt, and which also met the description of the individual who committed the bank robbery. He was found with a large quantity of money in new crispy bills, and in various denominations that actually Mr. Danner didn't point out, but they do match quite closely the denominations that were reported to have been stolen. He was found with what was described as a COVID mask and white or clear see-through gloves, or clear rubber gloves that were described by witnesses as being worn by the person who committed this robbery. On the way towards the store where he was found, which was Moose Jaw, there was a Starbucks, which he had told police that he was just inside. Right outside the Starbucks, in the trash can, there were handwritten notes demanding money, essentially the note that was passed to the bank teller, demanding money, no buy packs, if you want to get home. There was an additional item that was found with Mr. Ross, which was a small notebook that had some personal items in it. And also on some of the pages, there appeared to be sort of what attempts might have been made towards a bank robbery note of $5,000 and $100 bills, no die packs. This was all developed by the Ann Arbor Police Department after they arrived at the Chase Bank and started talking to witnesses. One of the things in the photos you'll see that I've submitted as People's Exhibit 1 for today's purposes is a photo of a screenshot of the robbery as it was taking place. You'll notice that the individual is wearing something about his head. It appears to be a scarf that wraps his head and face, and he's also wearing a what would be described as a surgical mask. So there's that. One thing that's very descriptive and is an example of the type of police work and what I described as good old fashioned police work of listening to a description, talking to various witnesses, and then putting it together when when the police made their identification of Mr. Ross as the bank robber can actually be seen in the photos that I submitted. If you look at, it's a little easier to see in number 2, but you'll see it in number 1 as well. Mr. Ross, when he was arrested, was wearing an inside out beige t-shirt. The image on what would have been the normal outside of that shirt is bleeding through and can be seen. That same image can be seen in the photo of the person robbing the bank. That's an example of why what Mr. Danner was getting at in his response as to why a lineup is unnecessary. And in this case, there is no mistaken identification. The police did their job. The police tracked down and identified the suspect with this and subjecting the witnesses to a lineup is unnecessary in this case. One of the things that Gwynn, which McAllister cited, that the court suggested the court should consider is that the court should look at, in addition to whether or not it would resolve anything, but the burden to the witnesses in doing so when weighed with. So, thank you.
Anything additional, Mr. Brown?
Yes, thank you. So the prosecution points to a picture. One of the things that has not been cited or stated is Mr. Ross had been in that bank earlier, and gotten changed, gotten singles. Problem is, we don't know what that picture depicts, when it depicts, or what's supposed to have happened. And that's a problem. But more importantly, Mr. Ross isn't charged with having items which may have been involved with a robbery. He's charged with actually committing a bank robbery. What the police are basing their information on is not the identification. And we have a misidentification. We have a person who was there and says, that's not the person who did it. They're looking in the car, looking directly at Mr. Ross saying, that's not the person who did it. When the prosecution says, well, we've got identification because this person had all of these items, and we have a picture of this person being in the bank. Well, when you put together the fact that Mr. Ross was in the bank earlier in the day and got changed, and the fact that for the police to even begin to try to pick up a suspect, they have to rely on identification. They have to rely on what someone told them this person looked like. And based on that information, they go and do whatever research it is they're doing, and they pick up a person. Then they're told by the witness who saw the person commit the robbery, that's not the person. Then you have an identification issue. You have a problem with identification because the police weren't there. They have to rely on what they're told. They have to rely on what's been said to them, how that person's been described. And when those people who have given the description say, sorry, that's not the guy, then you have an identification, have a controversy as to that identification. So,
Can I just, who are you asking to view this lineup?
the people who were in the bank, the people who were actually there, the security guard who says the person they saw had braids.
Okay.
The other teller who's there, who describes him as having no beard. And Mr. Ross, at the time he was picked up, had a full beard. I think fairness and justice demands that he be allowed to have an identification or eyewitness, a lineup, an in-person lineup, to make sure that they have not picked up the wrong person. Because remember, even if these items can be associated with the bank robbery, those items are fungible. That is inherent in those items that is attached to the person who committed the robbery. In other words, the items that they found on Mr. Ross could have been discarded by the person who actually committed the bank robbery. And if Mr. Ross picks those up, that still doesn't make him guilty of committing a bank robbery. That doesn't even put him in the bank.
But your proposition isn't that the people are relying upon an identification. Is that right? I mean, you're not arguing that the
people are relying upon this identification to say who the robber was.
They are, in fact. That's why they developed Mr. Ross, the individual they find in the store, as a suspect. That's why they say he's the guy. But
But
remember,
I thought it was not the recognition of the person as opposed to maybe what the person was wearing that led police in that direction.
and so they were told that the person had what, a white cap, that he had braids.
Well, what you said about what they were wearing, like the white and the like.
Yeah, there's certainly nothing unique about wearing a white shirt.
No, there isn't, but I guess. Because normally this is somewhat a little bit backward from what we normally end up with, is what I'm saying, and I'm trying to logic it through in my head.
Okay.
Because what brings the, again, I don't have the police report, but what it seems brings the police into contact is other identifying things that they receive from people that then bring them into contact with him.
Certainly not anyone who was in the bank who was an eyewitness to the alleged robbery. They have one person who says, "Hey, you're looking for a guy who looks squirrely. He's going to different doors." And that's how they end up going into the moose shop, because some person standing out on the street who was not an eyewitness to any bank robbery decides that Mr. Ross looks suspicious. And we can guess on what they base that.
So you're looking for the identification for the purposes that these people cannot say that it was your client.
They're saying specifically it was somebody else. They're just not saying, "Oh, well, could be him, could not be him. We're not sure." They're saying there was someone else who did. That's what they're saying when they say the person had no beard. Because they're saying when they say the person had either braids or hair. At the time, Mr. Ross was bald-headed, as he is now.
Right, but I guess. A little bit, okay. I think I get the argument. Like I said, it's just a little bit backwards from what one is accustomed to seeing, but. Okay. Anything else?
No, Your Honor, we would ask that the court grant our motion for a live lineup, because the eyewitnesses themselves have pretty much said that this is not the guy who did it.
When you said that, that reminds me, but the people's evidence isn't them saying it is him. Is it?
Well, that would be why he's here, I suppose.
Well, no, I mean, the reason he's here, I'm presuming, is, at least as I hear the people's argument, is because of what he was attired in and what they knew from the photos in the bank. And you may have your justification for him being in the bank. I get that. But that's why he's here. And maybe the person that you say there's somebody running in and out, running squirrely, okay, so that they follow that. But that's why I think he's here. There isn't somebody, as I'm hearing it, there isn't somebody that from the bank, from the scene, that is saying this is him.
That's true. There is not someone from the bank who's saying. In fact, we believe there are people who will say that is not him.
Okay, and that's where I get a little bit of my confusion. So then why would I have a lineup? Well, let me put it this way. Why would defense be requesting a lineup where I know that people are going to say that's not him, or I don't know who that is?
Because we believe that his sitting at that table is going to change that. And
Okay.
we want them to be able to come and say, "Oh, yeah, that's it. Oh, sure. Now
I see. I see. Okay. That's what you're trying to protect. I see. I get it now. If you just told me that, then we could have cut all of this out. Well, I was just trying to figure, all right. Anything else from the people?
Judge, I think you had it right where the people are relying on
what essentially I would say the corroborating evidence to establish the robber and Mr. Ross's identification. It's not that someone from the bank, we're expecting anyone from the bank to come in and say, that's the guy. Or to look at him because.
But I guess isn't the danger that they all of a sudden get in a proceeding and all of a sudden then say that is the guy? And there should have maybe been an identification beforehand. I guess one thing I'd ask, so from the people's standpoint, is they eventually have Mr. Ross in custody, at least to the point that they can bring one of the people down to attempt to identify Mr. Ross, right?
And they did.
And they said it wasn't him, or that doesn't look like the person. So why didn't they bring everybody down?
I don't have that answer. I don't know.
Just good old fashioned police work. Because that's what I don't understand, because I think that had that occurred, I'm probably not here hearing this motion.
So what I can tell you though, Judge, is that in reviewing the file, on the way back to the bank with Ms. Silva, the officer who's walking with her, gets the video from the bank, which that first shot that I gave you is from. Ms.
Okay.
Silva was saying she thought, as I recall, she thought he had a white hat on or something. Well, clearly he's not wearing a white hat. He's got white about his head in the form of the mask, but he's not wearing a white hat.
Right.
So, I mean, essentially, it's a thing of, as much as someone might be saying mistaken identification, the people are here and we will have to deal with what Ms. Silva said on the side of the road when they tried to do the show up. But what they had done before, in addition to trying to take Ms. Sleva down, they had developed this other information. $1,600 bills were stolen. $1,600 bills were found in his pockets. A total of approximately a little more than $2,600 was stolen. A little more than $2,600 was in his pockets. He had the orange shoes, which were distinctive, the white pants, which were distinctive. The shirt, which was somewhat distinctive. Although it was inside out, he was still wearing it inside out when he was found. The person outside of the Starbucks who said, he went into Moose Jaw. I mean, it was the same as if somebody was just, said, hey, I saw the guy running down the street and he went over there. That's how they found this. That's how they located him.
What's the harm from the people and just having the lineup?
That's the harm to the people.
Yeah, I mean, why oppose it? In a circumstance such as this one?
Sure. I would say, potentially re-traumatizing the victim who was robbed, who it took a few moments to figure out that she was surprised that this was happening to her through the form of a lineup and having to go through all this.
Traumatizing than the preliminary examination or trial itself.
Additional.
Maybe. Okay. I mean, but that's the only reason.
Well, the other thing is, I mean, I can see this as a tactic to just start inserting, trying to create reasonable doubt at this point. If the witnesses come and say, I can't say, that we're still in the same place.
Well, you may be in the same place, but you guys might be in the same place. I don't know that defense is in the same place.
Sure.
Because from the defendant standpoint, and it was the last thing that Mr. Brown said, what's going to happen is somebody, I'm presuming, is going to get on the stand, either at preliminary examination or at trial, and they're going to say, do you see that person in the courtroom? And they're going to point at it. And there's nothing that checks that in this particular type of case, because had they taken all 4 or 5 people down there, I don't think that that argument holds much weight, because now everybody has given their whatever statement they have, right?
Right. However,
But we don't have that.
correct. But then you have a different issue, potentially, where he's in the bank about an hour beforehand. And now it's an identification based on just seeing somebody very recently. And now.
Oh, absolutely, but you're always gonna have that.
Sure, but you're always gonna have the ability to cross-examine and say, look, you told the police you couldn't tell who it
Well,
was.
yeah,
What?
I know it's true, but I mean, I think the point is, especially if there's going to be a preliminary examination, some of these witnesses are going to come in. They're gonna look over there. That's gonna be what attaches. Potentially. I think more likely than not. And then it's gonna get later down the line at trial, but now that face is fixed.
Thank you.
I don't know that I need any additional argument. I mean, I wasn't following initially at first the defendant's argument regarding why they would want to light up. It was a bit confusing as to why they might in this case. When I think about the circumstances here, in this case is, I won't say it was unique because I haven't seen every case in the world, right? But it seems to me that it's a circumstance where the lineup may indeed be justified in this instance. I think it had the police gone, and if they had identified this individual as a suspect, and then anyone that may have gotten a glimpse of him, they go and do to show up at that point. I don't think we have this issue, but they bring one person down, they say it's not him. But I mean, there's always the danger, and it's a bell that you can't unring, that once they get in here, somebody who said something sort of innocuous in the police report, all of a sudden is now absolutely sure that this is the individual. And I think there's a huge danger at this point. So I'm going to order that a lineup be conducted in this case. Mr. Brown, you will prepare the order.
Thank you. Your Honor. We will prepare.
And that's for the witnesses that Mr. Brown was citing. in his motion.
Yes, for the individuals that were present in the bank that gave, I guess, really any description of that person. Because those are the ones that really are going to potentially be problematic. All right, so I'll grant the motion. We have one other issue, and I got a full courtroom here waiting, but on the 9th, I think defendant was here on the 15th, if I'm not mistaken. On the 9th, but not received by the court, I don't think at that time, he sent a communication into the court requesting, I think, kind of the stuff he was trying to tell me the last time that we were here. I'm going to take it neither side has seen that. Have you seen it, Mr. Brown?
Same thing I said today.
I've certainly heard of it, Your Honor. I don't think I've seen it, but I have heard of it.
I can compare that by sending me,
What?
I can speak, they did send, I got what I asked for, majority of what I asked for 3 days ago.
Here's a quick question. Would you like to withdraw?
Yes,
You want to withdraw the motion claiming ineffective assistant counsel of the person that just won that motion? What a concept. All right, I'll consider the motion withdrawn. Thank you.
Lauren Brown was not present for the June 6th hearing. The prosecution indicated they are working on putting together a lineup, but they haven't got that done yet, so I guess we're in to be continued mode.
I'll wait for the camera to go. Oh, this is, okay, we turned the camera on. I got you. Thank you.
You need to give me the whole story.
Court calls the case, People versus Virgil Ross.
We're
Alex
ready.
Chabalowski. Alex Chabalowski on behalf of the people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Virgil Ross. Your Honor, today is the date and time set for the probable cause conference. Based on the sentence agreement, Mr. Ross will be waiving his right to preliminary examination and agreeing to be bound over to circuit court. The sentence agreement is that Mr. Ross will agree at circuit court to plead to both charges, the bank robbery and the home invasion. And in exchange, he has also agreed to 8 to 20 years in the Department of Corrections. Is that correct, Mr. Chabalowski?
That is correct.
Mr. Brown, because of what was going on before, we had the camera turned off. There's not a reason now for that. Is that correct?
That is correct. There's no longer a reason for the camera to be turned off.
All right. Could we turn this? Thank you.
There you go.
All right. Sir, can you state your name?
Virgil Ross.
All right. Mr. Ross, you heard what your attorney indicated,
Yes,
and you understand that you're waiving your right to a preliminary examination?
yes,
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
yes,
And you understand you'll not have that hearing and you'll proceed to circuit court pursuant to the agreement.
yes,
People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on the single counts in both cases. Mr. Brown.
We acknowledge receive the information in both matters. My client will stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea in both cases. Pretrial will be set for
September 14th at 1:30 p.m. Judge Slade, Thursday.
September 14, 2023, 1:30 before Judge Slade, Thursday.
Thank you very much.
Thank you.
Mr. Ross.
That was 14.
Yes.